the supervising bankruptcy attorney at Lake Forest Bankruptcy. I represent individuals in the bankruptcy court, the Central District of California, and in consumer actions in state and federal court protecting the rights as consumers. I'm here to talk about a non-bankruptcy issue called the Homeowner's Bill of Rights, which is a state-constructed law that is in place as of January 1st, 2013. So I've been apprised that you are all involved in real estate one way or the other, as either brokers, realtors, real estate salespeople, loan officers, whatever, and that I should tailor my speech accordingly. So I have done that. Okay, so red button?
No. Went to the right.
Thank you. So we begin with, why should you care? First off, the reality is that realtors are often the first point of contact between a borrower or a homeowner and the rest of the real estate world or mortgage world. And as such, you will be asked about it. Now, you cannot give legal advice, of course. However, you should have an idea of what's going on with the Homeowner's Bill of Rights. Because there's already a great deal of misinformation. This speech was started because I received a number of phone calls from people who were, for lack of a better explanation, completely insane. They believed that foreclosures no longer existed in California, or that you couldn't, besides foreclosing, collect upon a mortgage anymore. So there's a little bit of misinformation about the law. And admittedly, the title of the law is horribly overstated. It's really not a whole Bill of Rights, and the title's a little fancier than the law actually is. You may be working on a short sale. You may be working on a real estate transaction. You need to know about this law if your client is concerned about it. Otherwise, it may kill your transaction. You may have wasted time. You may own a loan company. On the other side, this law affects loan companies. I've worked with realtors over the years. Many of them have an interest in a loan company that may now be defunct. Well, to the extent you originated a loan, that loan may be out there and you may be liable for the consequences if it's not serviced properly. And let's call it a crazy idea. As real estate people, you may own real estate. You may be interested in this law just for yourself. Okay. I like the clicker. This is fun. All right. Anything in this presentation that I italicize or underline means I think there'll be a problem in the law, or I think it'll be a difficulty in this law, and I will discuss that with you. But that's why it's italicized and underlined. Basics of HBOR. What does it do? It provides, unquestionably, a clear right to sue a mortgage servicer for screwing up on a foreclosure. Hitherto, what we had, if you wanted to bring somebody to court, was a hodgepodge of various other laws dealing with general principles of fairness and fair dealing in business. Basically, you had a breach of contract, breach of good faith and fair dealing, failure to present information, just these general concepts. And in a law school, in front of a law professor, on an exam, if you brought these things forward, maybe you had a good cause of action. Maybe you had an exacting complaint, and that was an A+ complaint. The problem is we're not in law school, and there are thousands of these motions, of these complaints filed every day, and the judges, doesn't matter where they are on the political spectrum, they hate them all. They're tired of them because most of the claims, 80%, are bad, poorly written, or just they don't have any foundation. And as such, judges don't like them, they don't like to see them. So when you actually get to court, the judge does whatever they can to quietly and not rudely boot your butt out of court because there's nothing there for the judge to do. Specificity is wonderful because a judge has an office and they need to run cases and they need to get stuff off their desk just like you do. So the more specific the law is, the more specific the remedy, they know what to do with it. And this law, and we'll go over it, is very specific. What it can do for you, what it can do for your client. And it provides clear and wonderfully identifiable damages. So we're not just talking about, oh, they've been harmed somehow. All right, no, there's actual dollar amounts that are discussed, remedies that are discussed, and mentioned and authorized by the law, which is fantastic. Again, judges, like all people, want to be lazy if they can. They want to get stuff off their desk. This law provides answers for that. Basics of the law. It addresses mortgage servicers on first liens. No seconds, no juniors, no HOAs, no judgment liens. It has nothing to do with them. Servicing on a first lien mortgage only. It does not affect anyone who is affected or is a party to the National Mortgage Settlement Act. This is a state law counterpart. The federal counterpart affects mortgages with Bank of America, JP Morgan Chase, Wells Fargo, Citigroup, and Ally Financial. This law does not affect any of those whatsoever. So you say, well, why are we listening to you, Anerio? Well, that does affect 60%. 60% of the mortgages out there belong with the big five, but 40% do not. So this still may come up. And there are a lot of loans out there, Altman, MetLife, some of the other ones that actually are far bigger than I ever thought they were. Those are affected by this law. And it is only for California, for residential homeowners in California itself. So to the extent you may do real estate in another state, this has nothing to do with them. Okay, who is an eligible borrower? Who is eligible for this law? Any individual, and it is an individual, and it has to be for residents, by the way, who is eligible for a federal, state, or lender foreclosure prevention alternative. Now, if you are not eligible for this for any sort of foreclosure alternative in any capacity, you actually are not eligible for this law. This is important. And it has to be offered by or through the mortgage servicer. Now, in California, all mortgage servicers have to, before they initiate the foreclosure, offer you something, some sort of foreclosure alternative. So this should come up most of the time. It concerns, as I said, only first lien loans. And it only affects owner-occupied residential property or containing no more than 4 dwelling units, so no investment properties whatsoever. And keep in mind, this is a case that will eventually go to court with someone on the other side who has an attorney who, if you try something clever saying, oh, it's actually my residential property, I just moved there yesterday. That stuff does get in front of a judge, and a judge will say, probably not your residential property. So this is basically on your first mortgages on your residential properties. An ineligible borrower could be anybody else, but I just wanted to make it a little more clear. I still like the clicker, even if it's not working with me. Okay. A person who surrendered the property by letter or delivery of the keys to the lender or agent. You send a letter saying, I'm done with the property, take it. You send the key saying, I'm done with the property, take it. You're not eligible for this law. And this is because they're aware of what people have been doing out there, and they're trying to get rid of the shenanigans. Now, in regards to shenanigans, notice italicized and underlined. You are not eligible for this. If you were a borrower who has decided to leave the home and has contracted with someone to advise on how to stay in the home, whose primary business is giving this advice, and avoid the contractual obligations under the loan. If you have contracted with anyone that could be construed as a scam artist for the purpose of keeping you in the home, you are not eligible for this. Or, if you have contracted with someone who is not a scam artist for the purpose of keeping you in the home, it can be argued you are not eligible for this. Now here's the problem with this part of the law. Not the first part. A borrower has decided to leave the home. Obviously, if you're not going to be in the home, you shouldn't have a remedy under this law. The part there's a problem is here. You've contracted with someone to advise on how to stay in the home. You have, as citizens of the United States, a First Amendment right to associate and contract with anyone for advice or services so long as those are legal in nature. This is saying you are not eligible if you have exercised your First Amendment rights. I think this part of the law, this one part, will be struck down within the next 2 to 5 years. And this law is good until 2018. I think that's too broad, and I think it's an unnecessary restriction on your First Amendment rights just to talk to people. Okay. If you are in bankruptcy, this does not apply to you. If you are out of the bankruptcy, it may apply to you. Very simple, that's all it is. If you're in a bank, because I get these questions as a bankruptcy attorney, hey, I'm in bankruptcy, I just got through my 341A hearing, can I, try to apply for this thing? No, you're in bankruptcy. Wait until the thing's closed. Ineligible lenders. There are lenders that this doesn't apply for. Signatories of the National Mortgage Settlement Act who are in compliance with that settlement. That part's certified, because if anyone falls out of the settlement, they're all fair game. It'll be a good time. The other thing, entities, this is if you own a loan company in any capacity, entities that have foreclosed on 175 or fewer residential properties located in California in the previous year. So for a lot of companies that may have closed down over the past couple of years and have sold off those mortgages to other servicers, they may not be liable to the law, or they have lesser restrictions under the law. Junior lien holders, as I said, doesn't apply to. And non-mortgage lien holders, HOA liens, judgment liens, things like that, this has nothing to do with them whatsoever. Okay. What does HBR, what does this actually stop? Okay, well, what does it require? It requires a couple things. One, notice requirements. Work with me, baby. Come on. Okay. Any person who is in the military, if you have a borrower in any capacity in the military and they're having problems with their home, you should see an attorney. The Service Member Civil Relief Act is an act that protects individuals who are in the military when things go down while they are in active duty. It is an extremely strong law and protection. It is one of the few debt collection protections out there that actually includes criminal penalties for screwing around with it. I once dealt with an HOA company that had sued my client, while they were in active duty in Iraq. And they attempted to foreclose on the property. So I sent a letter, said, okay, my guy's protected by the Service Member Civil Relief Act, you need to back off. It was the fastest freaking dismissal I have ever seen in my life. It was 2 hours after I sent that off, I got the dismissal paperwork. So wherever that attorney was on the other side, oh, because the criminal penalties applied to the attorney. They applied to the attorney representing the creditor. They must have just dropped everything that day, filed it, and just never want to hear from me again. It was fantastic. So service members receive special notice. Loan servicer must inform borrowers they have a right to request and obtain key loan documents and payment history. And this requirement, letting them know what they can get, it has to be... Okay. Really specific contact methods for the lender servicer. How they contact the person, the methods by which they contact them, they're delineated in the code. They are very specific. So if you have a person who may apply, this is where it would behoove you to seek an attorney's review to determine whether they've complied with these things. Failure to comply creates a cause of action under HBOR. Some of these things you've seen before, sending certified letters, they must call 3 times, they must actually attempt to contact the lender, to the borrower, they can't screw around with it, and we can go over that another time. Borrowers who hide. Now, I'm a bankruptcy attorney, okay? I have people who have been off the grid for years. I ask them if they received anything in the mail, they don't know. This part of their life is to take the mail and to throw it out. You need to pay attention, it really is. You need to pay attention, or your clients need to pay attention to the mail that they are receiving. Because if the lender is complying with the notice requirements and you're just not paying attention, you may not be eligible here. Okay, so hiding is not a good thing for you.
Anerio,
Yes.
can I suggest if you go the other side and then, because we can read
Okay.
and then everybody in the
I apologize.
Thank you.
No problem. Okay.
That would be good for clicking too.
I move fast. I can move down and do it. All right. The mortgage servicer must, if the lender has filed a notice of default, the mortgage servicer must send written communication to the borrower within 5 business days, notifying the borrower of their rights, and he or she may be evaluated for a foreclosure prevention alternative, whether an application is required by the lender, and, very importantly, how to acquire that application in detail. Contact us if you are interested. Does not work. This is going to have to actually be in the law, in the notice specifically. Go to this website, enter in this code, go here, download this, call this person at this number, and ask for this to be sent to you. General contact customer service is not going to be effective here. So they're requiring serious detail on these things. Information on the rights to apply, as I said, if you are eligible, and they fail to notify you that you are eligible, and they have foreclosure options available, it has to be given to you. Failure to give it to you creates a cause of action under this law. Okay. Now, following their own processes. Lenders have been given the opportunity to create their own processes for modification, foreclosure alternative, whatever they want to do. They've said, okay, create your own thing. That's fine. We have no problem with that. But we have one more caveat because the state of our nation is such that, oh, we don't know, we don't trust you so much. That caveat is that whatever process you create, you follow it. Failure to follow your own procedures creates a cause of action under law. Now, that's pretty cool. And I'll tell you why that's pretty cool in a second. Lenders generally, especially when they get larger, become, shall we say, less competent. Okay, and this is partially their fault, partially not. It's just in any business that grows, you have times in which you need to change and modify and put new things in place, and you can't. So when everything hit the fan, 2005, 2006, and we suddenly turned to the people who were servicing the mortgages, whose job it was to frighten us into making payments and saying, hey, you need to create loan modification alternatives, they sort of freaked out and fell apart. And that's hard. But at the same time, they make more money than I do, and I can sort of think about how you would handle this. You hire people who need work to say, okay, go work on this task, and so they could have gotten these things done, and they didn't. So they are going to have these processes up. I really doubt they're going to follow their own processes. I mean, you know, think about it. Altman in 2007
I was just saying.
put up a website to help people with modification. That website didn't work until 2009. Okay, that's 2 years. They just got sued. They didn't care because they could just pay the fines on it. All right. So, and they're one of the larger ones. Now, the big thing HBO prohibits, which David mentioned, is dual tracking. And we're going to go through dual tracking, whatever it effectively is. Okay. Now, it has to do with modifications, which is that while you are in a modification, they can't foreclose on you. And they're very specific about this. After you have received the application, which they have to tell you where to receive, after you filled it out and sent it to the place that they told you where to send it to, they have to send you back notice within 5 days. And I italicize and underline this because no one's going to make this. I'm sorry. They are not going to have their act together for at least 6 months on this one. People are going to send in their applications. They're not going to hear anything for like 30 to 60 days. But they're supposed to send back a receipt within 5 days. And not just a receipt. Ladies and gentlemen, there is so much trust engendered in the past couple of years. The lender must describe the process. What happens to your application? What happens to it? Okay, we have now received your application. It's not going off into the void anymore. It is going, whatever's going to happen to it. And they have to describe that. They have to tell you in that receipt what you are missing. We needed A, B, C, and D. You have A, B, and C, but you don't have D. So we need D. You need to send D to us at a certain date. And they have to stick to that date. So they have to tell you what they need, when they need it by, where to send it. And then after they approve your modification, you do have to accept it within 14 days. I should have actually underlined this one because I think borrowers actually are going to screw up on this one. Once a modification is offered to you, and you have to accept it within 14 days, or you lose it, or you lose your cause of action under this law. Okay. No modification fee is allowed. They can't charge you for this. That's a violation of the law, and one that I love, and I'll tell you why I love it from bankruptcy, is that no late fees on the mortgage payments while you are going through this process. The reason why I love this is that I practice bankruptcy, and in Chapter 13 bankruptcies, these are debt repayment plans by individuals with regular income where you go through the bankruptcy court, and when you go through the bankruptcy court, they have to account, the lenders have to account for their total finances, what they're charging you. Okay? They have, I've learned this, they have no idea what's going on internally. They cannot actually account or stop the late fees. They cannot stop fees because they have great machines behind them that the people on the phones do not control. So when the late fees issue, they're going to screw up on that. They have to say yes or no on the loan modification before they foreclose. That is definitive. If denied, the denial must tell you in detail why they denied the modification. And detail is something we're going to litigate. That's why I underlined it, because they didn't quite say what detail means. You know. You just don't think you comply with their program. That doesn't work anymore. No, it's got to be, you got to state why. Now, if you are denied, you have a 30-day appeal right. So if they deny the modification, you have 30 days in which to appeal that denial. And since there's no courts involved, we're presuming it's sending a letter back to the lender. And any appeal must include evidence rebutting the basis for the denial. This is where I think borrowers are going to screw up on this one. If they ask you for A, B, C, and D, and you never provided D, well, you can't say, well, I did provide D if you've never provided D. So I think they may screw up on that part of the process. If you, in that 30 days, did not appeal, on the 31st day, they can foreclose on you. Conversely, while you are in the modification, any foreclosure is obviously prohibited. So long as the borrower remains current on the loan mod, it's not so clear what happens. Like if you're within that year or so after the loan mod's been approved, do they go back to what part of the foreclosure process? That's why I underlined it. Any subsequent servicer must honor the modification. It's sad that this part I actually had to be made clear. Yes, you have to honor the contract. Spock! This law requires Spock. And I wish I had a picture of Leonard Nimoy to put up there. But SPOC is a single point of contact. The lender has to designate a SPOC, or, one of my favorite little parts of this, a team of SPOCs that can confidently talk to you about the loan. They must have information available about their own programs. They have to know what's going on in their own company. Call me crazy. They must coordinate their activities. I don't know what Bob's doing. Bob's assigned to your file. I'm on the SPOC team. That doesn't work anymore. No, all the SPOCs have to be competent. And they must be knowledgeable about the borrower's case. That part I think is sort of weird. Only because I have like 95 cases going right now. If you call me up about your case, I'm going to say, hold on a second, I'm going to reference the file. Am I supposed to know this off the top of my head? I don't know.
Yeah.
I think that part's a little vague. And they have to be assigned to you until you've exhausted all of your options. If you haven't exhausted all of your options, you still have the team of SPOC. They don't go away. Okay. And if you have less than 175 foreclosures in the last year, you don't need a SPOC. It's presumed that you may not be around anymore. Okay, just closing up. Death to robo-signing. Robo-signing is something the lenders have enjoyed over the past couple of years, whereby they haven't had to observe the law. And David brought this up, and it's something that makes all attorneys extremely irate. Because if I'm going to represent you in court, and I'm going to submit evidence to the judge, I need to verify that you have some idea of what you're talking about, and it has to be supported by evidence. That's how the rule of law works. For the past couple of years, lenders have asserted they don't have to comply with this. And I swear to God that is what they're doing in the courts. If they don't have to comply with verification or evidentiary rules because their systems are just good enough. And more than 50% of the time, the judges agree with them, which is absolutely maddening. Servicers can no longer commit perjury. There's a specific cause of action for this. Servicers can no longer utilize fraudulent documents. There is now a cause of action for this. Although it's sad that there is one, but there has to be. Bad servicers are subject to $7,500 for any individual shenanigan. Now, for those of you who know what a class action is, that's where a similar group of people sue a similar group of defendants. So like a bunch of people who, worked with Ocwen, say, and got screwed over at one time. If Ocwen's doing this in mass, you can sue for everybody. You're going to see some fun class action stuff on this one. It's $7,500 a pop. State and local government can also bring these suits. Certain state and local governments have been seriously harmed, or local governments have been seriously harmed by the foreclosure crisis. I think this law is for them to try to get everything back. In part, the law is for them. Okay. What this means to your client. They have a right to address any material requirement discussed herein. We're going to be litigating about the material stuff for the next couple of years. You can enjoin a foreclosure until the state court judge has agreed upon what's going on, whether the lender has actually complied with the law. Remedies may include actual damages pre-foreclosure, so any money you've lost pre-foreclosure, or if they foreclosed upon you, up to 3 times actual damages or $50,000, and the most beautiful language here for an attorney, whichever is greater. They foreclose on you while you're in a modification, your base request starts at $50,000.
What's the statute on that?
What do you mean, how long it lasts?
How long can they, how far back can homeowner go?
Only to starting for stuff this year, as of January 1, 2013. Also, attorney's fees have to be paid by paid to the prevailing party, which means that your debtor or your client may not have a lot of money. They can actually go to an attorney. An attorney may take this on contingency or reduced rate. So really quick, really quick. Okay, what will happen with this law? First prediction, nothing may change. We already have a bunch of laws out there that are not that bad, that may help people, and it's quite possible this law will go into effect and you won't see any change. Legal chaos will be the other one. There are, in my own building, at least 3 businesses that actually operate as attorneys but are not attorneys, doing loan modification and other scams out there. And any chance that they have to potentially sue somebody and keep somebody in their home illegally, they will do it. So this may create a lot of legal chaos. Also, people like me who make money suing, these companies, we may have some fun. So it could cause legal chaos. Third prediction, lenders freak out. They stop foreclosing until they become compliant with this in California. That's actually not good for anybody here because insolvency drives much of our businesses here. But that could happen, or any or all of the above. Could be a combination of things. Anyway, thank you very much for your time. If you have any questions, then we'll be able to.
Okay, so we're having